Welcome. And just to remind you all, 20 minutes aside. Mr. Kirkpatrick, you could reserve up to 5 minutes for rebuttal. Whenever you're ready, we're ready to proceed, sir.
May it please the court, Reed Kirkpatrick on behalf of Appellant Radney Foster and Judge Kazam, I would like to reserve 5 minutes for rebuttal.
Very good. Thank you, sir. You may proceed.
Your Honors, we're here today on a case of what essentially is a first impression regarding Florida's will reformation statute. Although that statute was enacted by the legislature back in 2011, my opposing counsel and I found very little Florida case law decisions, etc., interpreting that statute. In fact, the one case interpreting it was just on an evidentiary issue that just mentioned that particular statute. What I'd like the panel to consider is that Section 732-615, which allows the probate trial judge to reform a will pursuant to its provisions, was a sea change in probate law. Prior to the enactment of this statute and a sister statute in the trust context, which was adopted by the legislature somewhere in the neighborhood of, I want to say 2006 or 2007, the only reformations that could be corrected were Scrivener's errors and things of that nature. What this statute does is much more. It's very, very broad. And as I said, the case law interpreting this particular statute there's a dearth of it, this particular statute. What this court has done is interpreted the trust reform statute, which is found at 736-0415, and in the McGill, and I'm sure I'm mispronouncing that name, Rollo case cited in our brief back in 2015, this course, when addressing essentially the exact same language as in the will reformation statute, except for the fact of testator being included in the will reformation, said that the language of the statute is broad, without any language of limitation other than the heightened evidentiary standard. Any will, essentially under the will reformation statute, any will can be reformed, whether ambiguous or unambiguous, for any mistake, whether fact or law, whether that mistake was manifested in the expression of the will or in the inducement.
I'm sorry, Mr. Patrick.
Go ahead.
Sorry, Judge Crizell.
Go ahead, Judge LeBrecht. Go ahead.
I think my colleagues and I have read the run-up to this and have an understanding of the history of the recent adoption of this statute. Isn't the nut of this case, right, is whether there was whether the trial court erred by finding that the second prong was not supported by clear and convincing evidence, that the will didn't contain a mistake of fact, I think is the terms of the will. So could you address where the trial court erred in finding that there was not clear and convincing evidence to support the second prong of the statutory requirement?
Yes, Your Honor. Where the court erred is throughout the first prong and throughout the first, what I'll say, the 7 pages of that January 2020 order, the trial court found clear and convincing evidence that Dorothy Foster's intent, which never changed, was for her 2 sons to benefit from her assets at her death in a 50-50 status. And the court found, mentioned the 2012 will that predated, obviously, the 2018 will, mentioned the POD designations that were made up until about 2017 was the last one that the court recorded, and what the evidence was in the underlying court. Then she gets cancer. Strike that. Before we get to the cancer, she engages Attorney Fainer to start looking at what we'll call, and what the court called, a gift sale of the companies in question. And the companies were 2 pet cremation companies. And the original plan, as testified by Mr. Fainer and his associate, Mr. Silva, And what the court found is credible testimony, and specifically as part of the findings of fact, was that 1/2 of those companies were going to be gifted to Kevin Foster, and that he was going to effectuate a loan or buy out his brother from the other half of those companies.
And you know, Mr. Kirkpatrick, let's just assume everything that you're saying correct. As I read the judge's order, there's no question about her intent to make sure that both of them are treated equally. There's no question at all. The key issue, as I see this here, is was there a mistake in the will itself that can be corrected? And what the court basically said, well, if you look at the will, her intention's still there. Oh yes, this, you know, I'm going to give the cremation thing to, you know, son number 1, and everything else will go to son number 2. And so there's really not a mistake in the will itself. What the court said, that where the unequal distribution comes in, regrettably, is this pay on dash beneficiary, which is outside the will altogether. So I guess my question to you, that's not really a mistake on the will itself. Her intention is there. She wanted, you know, the son number 1 to get the actual business, son number 2 to get everything else. And so where I think where the crux is, where the mistake is the bank, the paying on is those the actual pay on death beneficiary designation on the investment accounts, which rather than the mistake itself in the will. So help me out with that. Why am I incorrect in that assessment?
Yes, Your Honor. Where the trial court erred is that the court again found that her intent was to give the way this 2018 will came about was that the devices in it would in fact carry out. Her mistake was that they would give the businesses this way so long as her other son number 2, Randy Foster, would get the remainder of her assets. The court found that was her intent. The court found that was her mistake, that she believed.
Excuse me. The court also found, and I think everybody agrees on this, it was her intent to treat the sons equally. It was all, and I think everybody agrees that it was her intent to leave the business to Kevin, right?
I would disagree with it was only her intent to leave the businesses to Kevin. It was her intent to leave the business to Kevin so long as Randy got an equal share of the other assets. The two are coupled together. The court found that,
but the remedy, the remedy that you've requested is to reform the will in a way that would effectively give Randy a 50% interest in the businesses, because that's the only thing the court could do, correct?
Correct, Your Honor.
And so this is where I'm struggling with how we would reverse this trial court. The trial court found that to reform the terms of the 2018 will to give Randy a 50% interest in the companies would only further frustrate Dorothy's intent, which was to give 100% of the companies to Kevin, who had been working in them while Randy wasn't. So help me out.
Sure. Again, Your Honor, Judge LeBret, what Dorothy's intent was that was found by the court, the underlying court, was to treat them equally. Where the court erred was to say her intent was to give 100% of the companies to Kevin by itself. That is not what her intent was. That's not what she expressed to Mr. Fainer upon signing the will. Her intent was to give the companies here so long as an equal value of her assets go to Randy. So
do you contend that the trial, I read in your brief, I think you suggest that the trial court incorrectly considered the inter vivos gifts that Dorothy made to Randy in the last few years before her death, where she gave him some cash, she was paying him a salary for not much of a job in the business. And the reason I'm asking that is that since we're reviewing the propriety of the trial court's determination that there wasn't clear and convincing evidence of the second prong, my question is, couldn't the trial court have relied upon that evidence to arrive at the conclusion it did with regard to the sufficiency of the evidence of the second prong?
Your Honor, the trial court actually, upon reading the trial court's order and reading our brief, I don't believe that we said that there was error in the inter vivos gifts. What the trial court found specifically was these inter vivos gifts that were done. There is no evidence whatsoever that Dorothy Foster's intent was somehow to keep a ledger and by this 2018 will trying to even up the score, so to speak. The trial court specifically found that that wasn't relevant, that there was no evidence to suggest that her estate planning, what would happen to her assets upon her death had anything to do whatsoever with any gifts that she may have provided to Randy Foster. So I think the record is very clear from the finding of the underlying trial court that he did not take that into consideration in any way, shape, or form. And it's specifically in the order, Your Honor, and on rebuttal, I'll find the specific page on it, but he was very, very clear that even though a lot of the testimony from my opposing counsel and the evidence that was trying to be put in was this theory that somehow Dorothy Foster was trying to equal what she gave in life and what she was giving post her death to the two brothers. He actually rejected that specifically.
Well, I can relieve you of the burden to look for it in the order because I know where it is. And
okay, all right.
It's on page 3. But I have this aversion to us revisiting the trial court's factual determination concerning whether clear and convincing evidence of the second prong existed. And in that, having read the trial transcript, there was quite a bit of evidence put forth. And so I struggle with the notion that the only way we get to where you want us to go is to reach the conclusion that the trial court improperly evaluated the evidence that it did have.
Well, Your Honor, if you go through and look at all the findings that the trial court found with what her intent was throughout it, it was not her intent until the very last few days, weeks of her life when this proposal, this inducement that, hey, by a 2018 will, we may be able to accomplish what you've been trying to accomplish since 2015.
Yeah, but who initiated this? Randy initiated it. Your client initiated it. You're not really arguing that the trial court excluded any material evidence, are you?
No, sir, I'm not. What I'm arguing.
So let's get on the same page. Trial court had all the evidence that you believe it should have had, correct?
Correct.
And your client got his mom to do another will in 2018 and didn't tell Kevin.
I disagree.
That's a raw summary. Well, your client was the only person there. So
well, my client wasn't there when the will was signed. And my client, there was actually a meeting in 2015 and in 2018 trying to get the gift by sale agreement at Mr. Fainer's office.
I don't want to get lost in the weeds. It's just the evidence was that Kevin wasn't involved in the 2018 will, period. Okay.
Correct. So
what we're looking at is the trial court accepting, according to you, all relevant evidence, all material evidence, and he is deciding and making conclusions as to the evidence. And intent is always a question of fact. And here's a non-jury trial. He's the trier of fact. The standard of review is clearly erroneous. It's not an abuse of discretion. It's clearly erroneous. We must believe that this trial court made a mistake. Just because you disagree with the trial court's conclusion is not enough. So help me out.
Agreed, Your Honor. Where the trial court made the mistake is he did not view the inducement part of it. He was looking for something in the will to show that there was a mistake in the expression. Well, the actual 2018 will was induced by and as the court found, by her asking, and in the hospital when she signed it, and Randy Foster was excluded, she said, I want to make sure that this will gives the companies to Kevin Foster and all the other assets to Randy Foster.
And Mr.
So I'm going to
It was told
interrupt.
that-
Can
and she
I
was told-
just,
I'm sorry, Judge Cassandra.
no, because I have the clock right here. You're about to get into your rebuttal time, so I just wanted to alert you of that.
Okay, I'll just finish that.
Can I
train of
ask
thought.
one last question? Because I think this is really the heart of your argument, or it goes to the heart of it. The trial court found explicitly that the terms of the 2018 accurately reflect Dorothy's intent. It leaves the companies and everything else to Randy, which is exactly what she intended to do. The unequal distribution results from the TOD designations rather than from a mistake in the terms of her 2018 will. And everybody agrees that she was sentient and competent to sign the will. So that's the fact finding that I think Judge Sleet and I are both drilling you on. And I'm sorry I've pushed you over your time.
That's okay. I would like to answer your question, even though it eats up my time a rebuttal. What the court found was that the 2018 will frustrated her intent. And what our argument is what the court didn't appreciate was the 2018 will, and her questions of Mr. Feiner induced her to sign it under the mistaken belief that the court found that all these assets would come through the will. So the 2018 will was induced by a mistake of fact that all of her assets would go according to the will. I realize that the law is different, it is not the case, but that was what prompted her by her very pregnant question at that point when she's going to sign the will, making sure that that was the case. And again, Judge Mathey found specifically that she and Mr. Feiner, her attorney, were under the impression that all of these assets would go through the will. That's the mistake, because the statute 732-615 is broad enough to allow the court to get out a pencil and rewrite the will so that it effectuates her overall intent, which he found through the first 7 pages of the order.
I'll tell you what, Mr. Kirkpatrick, I will save you the 3 minutes for rebuttal then, okay?
Thank you, Your Honor.
Very good. All right, excellent. Mr. Denman, if you could unmute your microphone, we're ready to proceed, sir.
Thank you, and may it please the court. I certainly don't mean this in any arrogant way, but essentially some of the questions and statements you made were the heart of my argument, insofar as upon reviewing the court's order, and again, we did not appeal the court's factual decision. The court determined that essentially that Dorothy had a mistaken belief that the POD accounts would pass through the estate under the will. So without...
Well, there was, just to cut you off, and I apologize.
That's okay.
The trial court heard a significant amount of evidence and saw some documentation, if I'm not mistaken, that Dorothy had a pretty good understanding of what the TOD mechanism was and where it existed in her overall financial picture. And we don't, correct me if I'm wrong, is there evidence in the record that would counter that understanding such that we could impute to her an inability to comprehend at the time she signed the 2018 will that somehow the TOD assets would be roped into her estate?
No, I think just the opposite. And I think that was my effort to put on the evidence to show that she was sophisticated enough to understand this. But again, I chose not to appeal that, so I didn't want to come in here and catch the wrath of the court for arguing something I didn't appeal. The court did make a decision that he believed that to be the mistake based upon the evidence. Personally, I believe the evidence was clear that she was astute enough to understand what was going on. Nevertheless, if you take that position of the court that is what she believed and that was the mistake as he put in his order, then we turn to the terms of the will, assuming that all of those accounts did pass through the estate, then the will is clear as to, according to the court, as to what Dorothy intended. And if that is clear, and the court said that after careful review and consideration of the terms, it cannot conclude that Randy proved by a clear and convincing evidence that the terms did not reflect her intent. At that point, as I believe is either Judge Sleet or you, Judge LaBrie, pointed out that the standard of view is whether the court's factual findings are clearly erroneous. The court found that Randy failed to prove how the terms could be different, where they would be different, and in order to break up the companies, that would further frustrate the intent. So to put this in perspective, we know that in 2012, the will was 50-50. We know that. And for whatever reason, and again, whatever the reasons Dorothy had, and that's why I tried to prove up the gifts, and the court made its ruling on that. But whatever happened between 2012 to 2018, Dorothy decided to change the will. If she wanted it to be the way that reformation is sought here, to be an equal split, then we'd go back to the 2012 will. But
this takes me to another finding that the trial judge made that I think is critical here, right? And what the trial judge said is a couple of things about how the will, what was asked of him to reform the will, right? To how he could reform the will. And what he found was that he couldn't, it was impossible to reform the 2018 will to effectuate her intent, for the simple reason that the only way that Feltner could have drafted a will would have been for her to change the TOD accounts, and she hadn't done that. And then to take the next step, the only thing the court could do to further effectuate her intent, which would be to split the companies, would further frustrate her intent. And those, I think, for the most part, are factual findings.
Yes, Your Honor, and I agree with that, because essentially, as in the Khalil case, which we attach as supplemental authority, which was a Delaware case ruled upon by a general master where there were two trusts and an account was named in the first trust, and the party sought a reformation saying that the account should have been named in the second trust. And essentially the court there said, well, if the settler wanted to have, all the settler had to do was change the account name. They weren't going to go reform and pull the account into the second trust. Here, the court, Judge Mathey, could not change the POD designation. He doesn't, those go directly. He could not do that. So to ask for reformation the way it's being sought here is essentially, let's use a backdoor approach to get what we can't get directly, because we know the court from I believe this is the Brown case, the Brown v. Brown, we know the court doesn't have jurisdiction to be able to pull those assets into the estate. So let's go around and do it backwards. But even if we assume for a moment that those accounts came into the estate, and this is where the critical issue here is, the relief that is sought, which is let's split the company, let's split everything 50-50. That's what she wanted. Well, that's what was in the 2012 will. If that's what she wanted, she wouldn't have executed the 2018 will. She knew at the time she executed that 2018 will, according to the court's order, and again, given without appraisals coming in lately, that Dorothy believed the company was worth $2 million. If we take the residual estate, if we take the accounts, we still don't have a 50-50 split. Absolutely not a 50-50 split. So in order to, if we go and we do a 50-50 split, there is no evidence that her intent was at the time of 2018, let's go reconcile whatever the overage is in the company and somehow put that back into Randy. The evidence presented that the court found that Mr. Kirkpatrick respectfully proved was that the mistake was that Dorothy thought the accounts would go through the estate. Even so, it would not result in any way in a 50-50. So for that reason, as the court pointed out, in order to then, Mr. Kirkpatrick calls the giving Kevin the 100% of the company was a secondary estate. I suppose, trying to trigger the maybe the Reed v. Sonder, but there's no evidence that it was a secondary intent. As a matter of fact, if anything, the evidence shows that the only reason for changing the 2012 will, the only reason, because otherwise it would have been 50-50, is to make sure that Kevin got the entire business. And it's unfortunate.
If I may, Mr. Denman,
Yes,
wasn't it
ma'am.
also testimony presented to the trial court that one of the reasons why she wanted to change her will is that she did not want to have one of her sons have to take, what is it, $1 million loan in order to buy out the 50% share of the other sibling. And in order to, as I read this, to put peace within the two sons, that the easiest way to do that is to simply give the business to the son who's really has worked in the business for all of these years. Isn't that also, it was part of the actual factual determination that was before the court?
Your Honor, I believe that there was evidence of that, and I believe that's, at least from my perspective, close to the mark. I think that I don't think that the evidence was clear enough, in my view, that because neither son owned any interest in the business prior to Dorothy's passing. So I believe that there was testimony about trying to do a deal where Kevin would get the business and give back some amount of money. But then there was also evidence we put on about that she was retiring and wanted to have money to live on, as opposed to that being directly to compensate Randy. I think that from our evidence, what we tried to put on is she was doing that in different ways, but she wasn't trying to say, Kevin, if you buy this, I'm going to, Randy, give you this, put an account for you that I'll hold till I pass. So that's the only place I disagree, but I do agree with
And I appreciate your response. I think it's you've answered my question. Then, and I guess this follows up with Judge LeBrit's question. There's really no evidence, or at least no suggestion at any time that Dorothy really suffered. I think the term was from diminished capacity, correct?
That's correct, Your Honor.
And in fact, there was even evidence presented that she knew exactly what her bank accounts were. She knew exactly that there was testimony as to how she was very savvy in that aspect of it. Is that correct?
Yes, Your Honor, I believe everyone testified to that.
So the question for us right now, when we review this, is to determine, we have a statute that says if there's a mistake in the will, obviously the main goal is to reform the will in order to fix the mistake. So the question here, as I see it, is that we have the trial court saying, I don't see a mistake here, because what the will said is exactly what was accomplished. The only mistake, if you call it a mistake, is the beneficiary designation on the pay of death in those investment accounts. And the court said, that's a different issue altogether. I don't have authority to undo that. This is for a different matter and not before me because we're only dealing with the will. We're only dealing, this is the probate case. We're only dealing with that to effectuate the intent of Dorothy. Am I understanding it correctly?
Yes, ma'am, you are. And I've struggled with this so many times on how, if you were to go back and somehow do a reformation of the will, as I've been saying, it's impossible to make it 50-50 because essentially we're therefore revoking the will, I believe, and under Forsyth, despite the arguments in the reply brief, I don't think Forsyth has been overturned because the purpose is to reform the will to correct the intent, not revoke it to go back to a prior will, because we know she intended to do something different. So then the question is, how do we split this up? Even in the record, if you may recall, there were memos created by Mr. Silva, the tax associate for Mr. Fainer, who went through at length discussing the differences between liquid accounts and a risky single-held business that may lose people. So for us to go back and to suggest that we should reform this, we're not reforming, we're rewriting the entire thing and essentially now saying, okay, should we take into pre-death, whether they may not be completely written inter vivos transfers. Do we take into equities? I gave you over here, the business is risky, here's liquid accounts. We're now essentially having to delve into her mind and not only know that she had a different intent, really just rewrite what we believe she would have done in that place. And I don't think we can, because there was not enough evidence to show that. It's not our burden to come up with ideas. It's respectfully Randy's burden to prove by clear and convincing evidence what the will should be based upon what the court's finding of the mistake. That's not here. And we still don't know. The one thing we do know is that it cannot be 50-50, because if it were, then she wouldn't have needed to rewrite the will in the first place. So respectfully, I don't want to keep going on. When I'm done, I'm happy to answer any other questions.
No, and you've answered my questions, and I don't know whether Judge Sleet or Judge LeBrit have any questions.
I don't. Thank you.
Thank you.
Very good. Thank you, Mr. Denman. All right, Mr. Kirkpatrick, I know Judge Sleet asked you, so I'm going to give you 3 minutes for rebuttal, sir. All right?
Thank you, Your Honor.
And Mr. Denman, can I trouble you to mute your microphone, sir? Thank you. Very good. Go ahead, Mr. Kirkpatrick.
Yes. First, in an inducement case, the primary question is, why was this will signed? And the underlying court provided us that, and specifically on page 6 of his order, beginning with on November 16th, the judge found as a finding of fact that Mr. Fainer had a telephone discussion with Dorothy and then recommended the new will based on this mistake that her investment accounts would go through the will. Furthermore, although we're not arguing, it's not part of this appeal, although I heard my opponent talk about whether or not it would be 50-50 or not, and had it worked out. The mistake, Mr. Fainer, through the documents that Dorothy was providing to him, had totaled up Dorothy's total worth at around $4 million in assets that included with that. Furthermore, the court found that Dorothy at that time in 2018 thought that the businesses were worth about $2 million. So why the question that the court answers throughout the findings of fact, why did she sign the 2018 will, was because the loan, and Judge Kazam, I respectfully disagree with you in terms of Dorothy didn't want Kevin to take out a loan. That's what they had been working on since 2015.
And that's what I was saying. I was saying that she did not want him to take out the loan. She was trying to maintain the peace. And if I gave you the impression otherwise, that was not the case.
Okay. Well, I guess I respectfully disagree with Your Honor's reading of the record, because there was no evidence that I recall or that the judge found that Dorothy didn't want to take Kevin Foster to take out a loan. Instead, the testimony that came through Mr. Fainer's office was she was frustrated that Kevin wasn't moving quickly enough to do the loan in order to buy out the rest of it. But the inducement here is, why was this 2018 will drafted and why was it signed? And it was because she was under the mistaken belief that, and induced to sign it by her own thoughts and by what her attorney told her in response to her question, that this was essentially effectuating what they had been trying for since 2015, and that's the Kevin Foster to get the business, but Randy Foster to get essentially an equal distribution of her assets.
Very good, Mr. Kirkpatrick. Perfect timing. You've approached your rebuttal time. All right, gentlemen, really, it's a very interesting case, and you both did a very fine job representing your client's position. Thank you both.
Thank you, Your Honors.
Thank you. All right, so the next case that we're proceeding on is the case of Anthony Deloach versus Lori Deloach.